All right, let's just dive right into this explainer. We're going to demystify this dense, honestly intimidating legal labyrinth of antitrust law that traps unwary business professionals literally every single day. Welcome to the show. Today we're unpacking a fascinating and highly critical paper from the Journal of Law and Criminal Justice. Because it turns out, the modern business world is heavily guarded by regulatory tripwires. Your next aggressive, market-dominating move might look like pure strategic genius in the boardroom, but to a federal prosecutor, it might look like a felony. We're going to break down the Sherman Act, the Clayton Act, and the globally shifting rules of competition to make sure you stay firmly on the legal side of the line.
We've mapped out this minefield into 6 main areas. We're looking at the core philosophy, restraints of trade, the totally counterintuitive reality of monopolies, pricing traps, global rules, and we'll wrap up with a really practical survival guide for your daily ops.
Section 1. The Antitrust Minefield. Look, to survive out there, you really got to know how the referee actually keeps score. So, ask yourself, who does U.S. antitrust law actually protect? Most managers just kind of assume it's there to protect businesses from unfair competition. Like if a massive corporate giant tries to squash a local mom-and-pop shop, the law steps in to save the little guy, right?
Well, here is the trap reveal. Nope. The entire system is built to benefit the consumer. We're talking better quality, lower prices. Which means hurting the competitor isn't always illegal if the consumer comes out on top. If a giant airline slashes prices to push a smaller rival out of the market, yeah, that's brutal for the rival. But initially, for you and me buying tickets, we get cheaper flights. The U.S. legal threshold focuses on whether an action ultimately harms the consumer, not if it just hurts a rival.
Moving on to Section 2, Restraints of Trade. This is where Section 1 of the Sherman Act comes into play. And let me tell you, the line between smart strategy and a federal crime gets incredibly blurry here. The law makes it illegal to agree to restrain trade, but what even counts as an agreement?
There is a stark, massive difference between legally following a market leader's prices and illegally colluding with a literal wink and a nod. The law completely allows for what's called conscious parallelism. You can sit at your desk, track a competitor's prices online, and match them penny for penny. Think of 2 competing gas stations on a corner. But the literal second you communicate with that rival to synchronize those prices, even implicitly, boom, you've crossed into an illegal agreement to restrain trade.
Just look at the U.S. chocolate market. It's a super tight oligopoly. Back in 2015, resellers actually sued these giant chocolate manufacturers because their prices kept moving in perfect unison. But the courts ruled that without a smoking gun, like direct evidence of actual collusion, independent, parallel behavior is perfectly legal. You really need 2 to tango to violate Section 1.
So the crucial takeaway here is knowing exactly where you sit on the supply chain. Agreeing with a direct competitor, that's a per se felony, automatic guilt. The court doesn't care if it actually lowered prices for consumers. But agreements up and down your own supply chain, like a manufacturer telling a retailer they can't sell below a certain price, that falls under the rule of reason. Courts will actually look at that case by case to see if it promotes better customer service or brand value.
Section 3, the Monopoly Paradox. We're getting into Section 2 of the Sherman Act now, which brings us to, honestly, the most counterintuitive reality in all of business law.
So what is legally wrong with having a monopoly? You dominate the space, you crush the market, surely the government is going to kick down your door, right? We've all been taught that monopolies are the ultimate free market villains.
Well, get this. Absolutely nothing is wrong with just having a monopoly. It's the act of monopolizing through abusive or predatory conduct that gets you into massive civil and criminal trouble. You can get a monopoly naturally through pure business genius, hard work, or even just historical luck. The law doesn't punish success. The crime only happens when you use intentional, exclusionary tactics to fiercely protect that monopoly. Like when Microsoft unlawfully pressured PC makers to exclude the Netscape browser just to protect Internet Explorer.
Take Gatorade, for example. They had a staggering 83% market share, but legally, not a monopoly. Why? Because giants like Coca-Cola and Pepsi had the massive resources and power to easily enter that sports drink space. Because that threat existed, Gatorade didn't have true, unchecked market power. Market share alone does not instantly equal a monopoly.
It breaks down into a very exact legal formula. Without a hyper-defined market, a massive market share, usually north of 70%, and unchecked market power, you just don't have a monopoly. You need all 3.
And, like we saw with Gatorade, if a behemoth competitor can easily pivot and challenge you, you lack the exclusionary power required to be labeled a legal monopoly.
But then look at Apple. When they orchestrated a push among publishers to raise ebook prices to fight Amazon, the court noted that a coordinated effort to raise prices was present in every chapter. Apple wasn't just being a neutral retailer, they were actively using their platform to help publishers horizontally collude. The intent to manipulate the market was undeniably clear, making it a directly punishable offense.
All right, Section 4, the pricing trap. Now we're navigating the highly treacherous waters of the Clayton and Robinson-Patman Acts. This is an area where standard, everyday business practices violently crash into federal law.
Let's say you have an absolute rock star client. Can you legally give them a major exclusive discount? Common business sense screams yes, reward your best buyers. But under price discrimination laws, charging different prices to competing buyers for the exact same goods can trigger a massive lawsuit. If you sell identical commodities at the exact same time to two competing retailers and you give one a better deal just because you like them more, you're stepping right into a trap.
You only survive this trap if your discount strictly aligns with a few very specific, highly documented exemptions. Like if a customer buys in such massive bulk that it legitimately saves you real shipping or manufacturing costs, you can pass those savings on. You can drop your price to meet but strictly not beat a competitor's lower price. Or if your goods are highly perishable, like literally bananas about to rot, you can slash the price to move them. But you absolutely must have the paper trail to prove it.
Section 5. Global Antitrust Laws. For anyone managing operations overseas, listen up. Stepping outside the U.S. means stepping onto a completely different legal battlefield. You absolutely cannot assume American legal logic applies everywhere else.
The rules shift dramatically across borders. The U.S. focuses heavily on the consumer, right? But the European Union, they actively protect competitors in the common market. Japan relies heavily on slapping companies with massive surcharge payment orders. China aggressively intervenes in global mergers with unique hold-separate remedies. Remember when the EU stepped in to block General Electric and Honeywell from merging, even after the US said go ahead? Or Qualcomm paying almost $1 billion in China for alleged unfair trade practices. Going global requires a hyper-localized legal strategy, for sure.
Finally, Section 6, the Manager's Survival Guide. We've mapped out the minefield, so let's get to the rapid-fire, actionable stuff that keeps you and your company out of court. Consider these absolute non-negotiables for your corporate code of ethics.
I honestly cannot stress this enough. Trade association meetings are the ultimate danger zone. Yes, they're great for networking or setting industry standards, but if competitors start casually chatting about pricing or territory divisions over drinks, you must loudly object, get your objection on the record, and literally walk out the door. Then call legal. If someone suggests fixing the supply chain issue by coordinating prices and you just sit there silently, that silence can and will be interpreted as an implied agreement.
And there are absolute per se deal breakers you can never ever cross. Never agree with a competitor to set prices, never agree to chop up customers or sales territories, and never participate in a group boycott. There is zero legal defense for these horizontal restraints. They bypass the rule of reason completely. It doesn't matter if dividing up a state helps two small companies survive a giant rival, and it doesn't matter if it ultimately makes things cheaper for the consumer. These are inherently illegal. You have to make your pricing and territory decisions completely independently.
So, I'm going to leave you with this final thought. Your next incredibly aggressive business strategy might look absolutely brilliant on a whiteboard, but is it secretly a legal trap? Before you move to totally dominate your market or offer that next exclusive bulk discount, triple check that you aren't accidentally stepping onto an antitrust landmine. These laws are super nuanced. They're built to foster fierce competition while strictly punishing collusion. Your best offense is a killer product, but your ultimate defense, that's a total mastery of these legal boundaries.